Hello everyone, and welcome to today's webinar. We have a great session lined up for you today. Before we get started, there are just a few general housekeeping points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. Second, if you experience any technical difficulties today, please use the same question tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of the recording with you via email in the coming days. So, without further ado, I'd like to hand over to our speakers to get us started.
Thank you, Mona. So, yes, good morning, good afternoon, good evening to all the attendees joining us from different parts of the world. A warm welcome to our esteemed speakers, participants, and guests to Mason's masterclass in association with GAR on a pivotal aspect of engineering projects, that is practical completion. So my name is Ravina Agarwal and I am the moderator for this masterclass. In the realm of construction and engineering, achieving practical completion marks a significant milestone, signaling the conclusion of the project's primary construction phase. Today, we embark on an exploration of this fundamental concept, delving into its definition, implications, challenges, and best practices. At its essence, practical completion represents the point at which a project is deemed sufficiently finished for its intended purpose. However, this definition merely scratches the surface of its complexity. So when I say practical completion, it is not merely about reaching the end of a construction project or end of a construction engineering project or anything, but to ensure that the project meets predetermined standards of quality, functionality, and safety. It forms a crucial juncture in a construction contract, triggering various obligations and entitlements for both the parties involved in this project. Understanding the intricacies of practical completion, their clauses, the defect liability periods, the completion certificates, everything is essential for navigating the contractual landscape of engineering projects. Now, I move on to today's discussion, where we will be confronting the challenges associated with practical completion. From contractual disputes to technological disruptions, we shall explore how industry professionals can navigate these obstacles and harness innovation to streamline the attainment of practical completion in engineering projects. So, this is an extremely pertinent topic, and we have assembled a panel of experts who will share their insights and expertise on different aspects of this topic. Now, before I present the stage to our speakers, I'll take this opportunity and briefly introduce all our speakers to our audience members. Firstly, I would like to welcome Lucy Garrett. Lucy, currently associated with Keating Chambers as a King's Counsel, was called to the bar in 2001 and was made Queen's Counsel in 2018. She has an impressive specialist practice in construction, engineering, energy, and shipbuilding, with a particular focus on projects involving complex factual, technical, and contractual disputes. Her practice includes claims for and against construction professionals in these sectors and project-related issues such as insurance, bonds, and guarantees. Lucy also advises on and acts in adjudications from referral stage to enforcement. Next, we have on board Aarti Thadani. She is partner at Norton Rose Fulbright. She is a construction dispute resolution lawyer based in the Dubai office. She has been at the firm for over 13 years and has practiced in the construction and arbitration teams in London, Singapore, and Dubai. Aarti regularly advises regional sovereign wealth funds, master developers, and owners on complex construction projects in the region. She has a substantive experience advising on MEP-related contentious issues and final account disputes. Next, we have with us Giovanni Parna. Giovanni is a senior in-house legal counsel, currently working at Meyer Technimont with a broad experience in international dispute resolution, construction law, contract, and claim management. Before joining Meyer Technimont, he worked for major corporations and consulting firms like Siemens and Ernst & Young in the Americas and Europe. Since he joined Meyer Technimont, he has managed several high-key international arbitration cases, mainly related to engineering, procurement, and construction contracts for oil and gas, fertilizing, and power projects in Middle East, Asia, Russia, Europe, and Latin America. Next, I'd like to introduce Andrew Mackenzie, partner at DLA Piper. Andrew is a qualified English law barrister, solicitor advocate, and arbitration law specialist. Apart from advising on complex commercial disputes, Andrew also specializes in construction, engineering, and energy disputes. He has tried cases in all of the major arbitration formats, including ICSID, ICC, LCIA, SIAC, ADCCAC, UNCITRLA, and DIC. He also holds full rights of audience before the DIFC and ADGM courts. He sits as an arbitrator and has written and presented at numerous international conferences on arbitration and dispute resolution. Last but not the least, we have Farhan Khan, partner at Nissin, with over 16 years of dedicated experience in the construction industry. Farhan specializes in project advisory and disputes. His expertise includes project management, delay and quantum analysis, and providing expert witness testimony and the report. With a wide range of industry experience, including oil and gas, real estate, airports, power plants, and infrastructure, Farhan offers comprehensive support across various cases. He excels in delivering precise, credible, and compelling reports and testimony, whether navigating technical details or distilling complex concepts into accessible language. I'd like to welcome each of the speakers for today's topic. As we delve deep into the topic, we invite our speakers to share insights into the best practices and lessons learned in the pursuit of practical completion. By drawing from collective witness and diverse perspectives, we aim to distill actionable strategies that can elevate the success rates of engineering projects worldwide. I would also like to reiterate and invite our audience members to put in their questions, if any, in the Q&A box. Our speakers would be happy to take up the questions during their time or after the session as they think fit. Now, without any further ado, let us commence our masterclass on the concept of practical completion in engineering projects. So, first of all, I would like to set a context. So, we see that a large number of projects enter into arbitration in the last stages, when the project is almost 95% complete and only merely like a snag or punch list items are remaining. At such stages, the employer has usually started making beneficial or commercial use of the project. However, it does not provide a completion certificate to the contractor in most of the cases. So the snag works are always difficult to complete and take longer time due to interface issues or other pending issues. Even the LD is levied on the contractor due to delay in completion of those snag items. So my first question goes to Lucy, that what is the position of English law on practical completion and LD applicability if commercial or beneficial usage is being done by the employer? Lucy, to you.
Thanks, Ravina. Under English law, this is quite a tough situation, which I I'm going to say that thing that clients always hate, that lawyers always say, which depends very much on the facts of what's happening on the job. The starting point is always going to be that the contract says that practical completion has got to be achieved before liquidated damages can stop being levied for delay, assuming there's no extension of time. And that means that the contractor is going to be in a 1-0 down situation. Obviously, it's the contractor's site, so the employer can't usually come and start using the project unless the contractor agrees. They can't unilaterally enter in on the works. So normally when this happens, there's actually an express agreement that's reached between the employer and the contractor, because otherwise the contractor can say you can't come in. And that agreement usually involves some kind of deal about how LDs are going to be treated. Are they going to be reduced down, contractually reduced down as part of a new agreement, so a side agreement is entered into. If the contractor is in the unusual situation where the employer has unilaterally come and taken possession of some of the works and is using the asset for its own commercial purposes, then the contractor might, in the right circumstances, acquire an argument in English law that the liquidated damages have become an unenforceable penalty. And as I'm sure everybody on this call knows, the test for that changed a few years ago when the Supreme Court issued its decision in Cavendish. In practical terms, my experience in real life is that although the formulation of the test has changed, in practice, I don't think it is that different to what it used to be. But the test originally was, are the liquidated damages a genuine pre-estimate of the loss? And it was only if the LDs bore absolutely no resemblance to the loss, were extravagant and unconscionable, and were only intended to deter a breach of contract as opposed to compensate, then that would be an unenforceable penalty. Post Cavendish, the test is whether the LDs impose a detriment out of all proportion to any legitimate interest of the innocent party in the enforcement of the obligation to complete on time. But the Supreme Court did say that the old test would also be useful and quite often would give you the right answer. So one can imagine a situation where the work's almost complete, the employer's using it, still levying the full LDs, and they might become a penalty. But as I say, in my experience, generally, because the contractor can contractually keep the employer out of the site until PC has been certified, generally speaking, the difficulties arise where the contractor has entered into a side agreement with the employer, but then it becomes difficult to interpret what that side agreement meant, or it doesn't cover some specific point that's come up during the final stages of the project.
Yes, understood. That's that's helpful. So I'll now ask to Aarti that whether is this same applicable in UAE? What is the position of UAE law on the same? Does UAE law allow for the reduction of LD if actual loss is not suffered by the employer owing to delays in completion of snacks?
Thanks, Ravina. I think when we speak about the UAE, as you will know, and I'm sure everyone on this call is probably aware, there are different legal jurisdictions operating in parallel within the UAE. We've got onshore UAE, the DIFC, and the ADGM. Now, I think it's fair to say the DIFC and ADGM law positions will, broadly speaking, reflect the position as explained by Lucy a few minutes ago, but for a few nuances. Now, the position in onshore UAE is slightly different. And I should say that I'm not an expert, and I don't put myself out as an expert on onshore UAE law. But I think there are 5 key principles at play here. Good faith, the requirements outlined under Article 246, parties should be fair, proportional, and reciprocal. Then abuse of rights. So a use of a right is unlawful when the expected interests are not commensurate with the prejudice sustained by the other party. We've also got principles in onshore UAE law on unjust enrichment, Article 318 of the UAE Civil Code, which provides no one is entitled without cause to enrich himself to the detriment of another person without just cause. If he does so, he's liable to restitute it. And then we've got the treatment of liquidated damages in the UAE. And liquidated damages provision should really be enforced under Article 319 of the Civil Code. Having said that, as I'm sure those on this call are aware, the UAE courts have significant discretion to intervene and revise the parties' agreement. And so typically, contractors may claim the liquidated damages provision should be reduced when no loss has been suffered. And employers often find proving their loss to be a significant hurdle, particularly from a causation perspective, especially if the employer has taken beneficial or commercial use of the asset. Just to flag a small point here. At the outset, the employer does not need to provide evidence before levying liquidated damages. The burden is really on the contractor to challenge the LDs and demonstrate that the employer did not suffer the damages claim. Now, if the contractor is successful, the onshore courts can amend the LDs clause to reflect, to require the employer to demonstrate actual loss. Having said that, just going back to a point Lucy made, I think much has to do with the contractual terms and the factual, the factual position on site. Usually under the typical standard form contracts used in the region, substantial completion and practical completion are not prescriptively defined as such, as is the case with the criteria for issuing the TOC, and there is an element of subjectivity. And so there may be valid reasons for the employer to withhold the TOC. And I say that because, I think, yes, there are snags, and yes, there are minor outstanding works, but 95% completion doesn't necessarily mean that all major works have been completed. And I think if, so even if we're at 95% completion, the employer may have reasons to still withhold the TOC. I think the bottom line, though, is the approach on the onshore UAE law will be to look to try to reach an equitable result, bearing in mind the specific facts. Was the employer justified in withholding the TOC? And then ultimately, the employer may be tasked with having to demonstrate actual loss. That's all I wanted to say for now.
Thank you, Aarti. So moving on forward, I understand from the points what we have discussed as of now. So we understand that it has been seen that contractors are unable to complete those last few items, or we can say snag items, that is the remaining 5% of the project, either due to commercial disagreements or due to interfaces. It becomes burdensome for the contractors. Even there are instances where the contracts have been terminated or the BG is encashed, and there are other issues. So I'll move on to Andrew to know that what will be your advice to contractors and employers, both the parties, in such instances.
Thank you, Ravina. I think the initial advice given to both sides is not to act in haste when dealing with this particular issue, because the definition of what a snag is can often be somewhat subjective. As the two earlier speakers have said, snag items can range in terms of size and importance. When a contractor says to me, what is a snag item? Of course, the majority of people's minds will go to a relatively small issue that needs to be resolved, but not one that goes to the substantive use of the actual project itself. And we will come on to discuss that further on in the masterclass in terms of that specific definition. But as crazy as it may sound, if you adopt that sort of, this is a minutia item that needs to be resolved, but the contractor is frustrated in being able to resolve these issues. And of course, that's from a contractor's lens. If you flip the lens and see it from the employer's perspective, the employer may find that the contractor is deliberately dragging their heels because they've mostly down tools, they've decamped from site, their focus and indeed their cash flow is often on the next major project, and they don't want to come back to site sometimes to resolve those smaller, less substantive issues. But you can see it from either side of the lens. But as crazy as it may sound, we are constantly dealing with issues for clients where termination is a very real risk. And it may sound somewhat incredible to people on the line that an employer may ultimately terminate a contractor who's done 99.9% of the work. And I would caution any employer with respect to any action in that regard. Termination, indeed, what can often be finally determined as unlawful termination, is the nuclear option. It is not something you should do without cause, without justification, and without the practical issues in mind. Yes, it is the contractor's obligation to remedy the snags on site. They are duty bound to do that. Is the refusal to come back and perhaps paint a specific wall or adjust a door in a large-scale hospital project going to vastly impact your ability to use the final project, using hospitals as an example? The answer to that is simply no. Practically speaking, you can obviously bring someone else in, but flipping it to the employer side, you should give the contractor the opportunity to remedy those defects, as small though they may be, and indeed, contractors, you should remedy them, because the consequences of not doing so, particularly in the Middle East, can be very severe. The encashments of bonds, parent company guarantees or performance bonds is one such consequence. And again, for those on the line thinking, well, there's no way an employer would ever encash a performance bond to the full limit of the value of the bond, which is often 10% of the total value of the project, more so if it's an advance payment bond, then ultimately, unfortunately, we live in a world where that does happen. And we're dealing with two very large-scale arbitrations at the moment, valued over $1 billion in dispute, where both for the contractor and the employer were acting on two separate matters for two separate sides. They have had instances where the contracts were terminated simply because the snags were not remedied. About 4 to 5% of the work was not complete. And because bonds often in this region are on demand, the full value of the bond was called. Now, from an employer's perspective, you can what's called salami slice the bond. You can ask the bank, even though it's an on-demand full payment bond, you can write to the bank and say we wish to call a portion of the bond. That is a reasonable step, practical step to take if the a contractor is refusing to come and remedy the defects. And to be fair to the employers, these defects can range in cost and time value. Yes, fixing one door or a hinge or something relatively small, like some chipped paintwork in a reception, can seem relatively small beans to most employers or even contractors. But if you project that across a very large scale infrastructure project, let's assume every major door or hinge in the project was broken or was not working in compliance with the specifications, that's actually a significant time and cost that the employer would incur to fix it. So they should afford the contractor the opportunity to remedy it. If the contractor refuses to, and please do put this in writing, employer, make sure you give them a reasonable amount of time to highlight again the part that Artie mentioned earlier. The requirement to act in good faith if your contract is governed by UE law is paramount. So make sure you document clearly that reasonable time is being given. If the contractor then still refuses to comply, then salami slice the bond. Do not call the full bond, because you will be inviting substantive proceedings for the recovery of that bond. And that means you have to deal with lawyers a lot more often than you would want to. So we will be invited into the world, and suddenly you have a formal dispute between the parties. If a bond is called and it's an unreasonable call on the bond, it is possible, as many of you will know, to seek an attachment on that bond, that attachment will remain in place if substantive proceedings are commenced. And all of a sudden, you're off to the races. You're in arbitration over a matter that may only be, let's say, $100,000 worth in dispute. If you call the full bond, you're inviting the other party to commence proceedings. It's going to let you walk away with 10% of the contract price when the project is predominantly complete. So from an employer's perspective, be reasonable, document. If the contractor still refuses, then you could salami slice. From the contractor's perspective, again, if this happens, if you find yourself in a position where the employer is threatening to call the bond, make sure you clearly document the position that you've attempted to get to site, that you have indeed rallied your resources to fix this, but the employer is obstructing you, or other contractors are obstructing you. And that's not unusual either. You find instances where contractors are invited to site but cannot access the site. And it's very unfair if a contractor is given a specific time and day and day range to attend the site to remedy defects and finds himself in the unenviable position of not being able to do so, because time is money. And ultimately, they should be afforded the opportunity to remedy those defects. If you're not documented clearly, if the employer proceeds to terminate, you can bring a claim for unlawful termination. If the employer calls the bond, immediately appoint counsel and seek to attach the bond. Because you have acted correctly, you have acted fair and in good faith, you have tried to comply with your contractual obligations, but you have failed to do so, and the employer is then acting ultimately unreasonably. So on both sides of the fence, stop, think carefully what you're wanting to achieve. You're wanting to achieve the completion, the amicable completion of the project. And there's no reason why at the 11th hour it should turn towards the nuclear options. So take a step back, breathe, look at your contractual rights, make sure that you're being reasonable and sensible with your interactions with either party, whether it's employer or contractor, and ultimately don't act in haste.
Yes, that was quite interesting and insightful, Andrew. But I'd like to add on to it. So what happens, so when we understand the circumstances from both the parties' view, so can practical completion be achieved in such circumstances? Like what happens in a situation when some major items of work are pending, for instance, in an oil gas project? If commissioning is delayed due to issues beyond the control of the EPC contractor, such as, for example, the provision of hydrocarbons. So will the contractor be relieved of its responsibilities, or would it have to continue to maintain its resources at the site?
I mean, generally speaking, if substantive matters remain unresolved, then the contractor is not off the hook. Completion and compliance with the contractual obligations will keep the contractor on the hook until that completion is ultimately achieved. Where it becomes more nuanced, and every case indeed turns on its fact pattern and the contract that governs it. But ultimately, if the contractor is being frustrated by an outside third party, then you must put in notification. You must take measures to mitigate, because you should not continue to run your site fee to the employer's cost. The party is ultimately responsible for the frustration. But we have had, and I have dealt with contractors in the past that think they're afforded some sort of silver bullet or get out of jail free card because a third party has come along and frustrated their ability to comply with the works. And contractors believe this is a great opportunity to excuse all their prior delays to the project and ultimately put their hands up and say, we can't achieve practical completion because we're being prevented to do so. And some of them indeed have defaulted to believing that practical completion has been made because they've done everything they possibly can. And that is not how the contract works. That's not how the law works. So again, it's back to documenting very clearly what has happened, setting out very clearly what your rights are under the contract. If you are being frustrated to ensure completion of your works by an outside third party, or indeed the employer themselves, that gives rise to certainly an application for an extension of time, potential prolongation costs, and mitigation efforts and costs accordingly as well. So it isn't a case of simply walking away and saying, I'm done, I don't need to complete. You can't simply specify that or deem that practical completion is complete. We will come on to circumstances where that where smaller items, less substantive items, remain outstanding, and yet practical completion has been achieved simply by virtue of the fact that the facility or the infrastructure project is in use or has been taken custody of. But that's not the case here. A critical issue has not been resolved. A critical facet of the project has not been complied with, and therefore you must ensure that you comply with your contractual obligations to ensure that those items, those major items of defects, are ultimately completed. It may take time, it may take additional cost, but that gives rise to further claims.
Yes, correct. So thank you, Andrew. So I'd like to move forward and ask Lucy that when I understand that the contractor cannot simply demobilize from the site and declare completion. But then, like from my experience, if I say that there are issues where for a year or so, these snag lists are not being completed and the project is going on, and only 5 to 6% of work is remaining. So what are the legal rights available to the contractor in such instances? Lucy, to you.
Very 2020 mistake, isn't it? If you've, I think there's quite a big difference between some snags remaining and there being 5 to 6% of the work remaining. 5 to 6% of the work seems to me to be quite a substantial amount of work, and I don't think that you've achieved practical completion on any view if 5 or 6% of the work remains to be done. Snags are going to be under 1%. I would say if you could even quantify snags by a percentage, it should be really small last things. And as a matter of English law, if it really is only snags that are pure snags that are left, then you've got an argument that in fact you are finished under the contract, that practical completion has been achieved. In most EPC projects, there's a specific list of boxes that have got to be ticked to meet practical completion. So it won't be a question of whether you've got snags outstanding. It will be, have you done this piece of commissioning? Have you had this signed off properly? Is it all working? That's usually the thing that's happening at the very, very end. That's taking longer than anticipated and causing problems. And I think, really, as Andrew has said, whichever side of this argument you're on, whether you're on the employer side or the contractor side, it's key that you try and document, whether in correspondence or in meeting minutes, what your view is as to what the true cause of the issue that's holding up completion is. What has gone wrong? What's preventing work progressing, and why does it prevent work progressing? And what the solution is going to be to that, the technical, practical, on-the-job solution, which usually everybody can agree on. It's not usually difficult to work out what should happen next. It's a question of who's going to pay for it. And certainly, as Andrew said, anyone doing anything precipitately like demobilizing is taking an enormous risk and probably precipitating the project into a formal dispute, which is always very expensive. Much as I love formal disputes and everyone having to pay lawyers, from my own personal point of view, it's definitely not in the interest of the parties. From the contractor's point of view, really from both sides' point of view, the key is what's causing the problem, what's causing the delay, and whether that particular cause of delay falls within the list of matters that have been allocated to the employer's risks as grounds for extension of time. And also, obviously, whether they're going to found a claim for increased preliminaries on the part of the contractor for keeping his site presence there for such a long time. And really, I think from the contractor's point of view, they want to be identifying whether any of the causes fall within those categories, and then making sure they're giving any relevant contractual notices, so that they can actually run a claim for time and money over the relevant period if the project is actually being extended by something that isn't their risk under the contract. So, I mean, I think in your previous example that you're discussing with Andrew, you were saying, well, what if there's no hydrocarbons, so that the I don't know, final commissioning can't be done because you need a flow of hydrocarbons to operate the equipment and commission it. I think we've probably all seen that kind of issue come up quite a lot. That would almost certainly be a ground that entitles the contractor to an extension of time, because the contract will say that the employer is under an obligation to supply the hydrocarbons for this to happen. So it would fall under, if it wasn't a more specific, ground, it would fall under the catch-all that one normally sees of an employer breach or an act of prevention. And so that effectively one carries on operating the contract, notwithstanding that everyone might feel that you're in the kind of last gasp moments of the project and you're almost there. And that's really the only way that both sides, contractor and employer, can protect their position. That can sometimes be very tough on the contractor, because it's usually the contractor that's incurring upfront costs in maintaining their site presence and also carrying out work for, carrying out additional work with materials and that kind of thing. So I appreciate that this advice on a live project basis is usually more onerous on the contractor than it is on the employer in terms of who's spending the money right now. But I think it pays dividends later on in terms of having a clearer picture for the dispute and a clearer claim, and also you're avoiding the potential of a much bigger loss all around if somebody walks off just before the walks off site or gets kicked off site just before the job's finished.
Understood. Thank you, Lucy. So, moving on forward, I would like to ask Giovanni that in engineering projects or energy projects where there is huge scope of work, we have several terms like mechanical completion, and overall completion. What is the difference between these terms? How to address when these terms can be assigned to a project?
Okay, thank you, Ravina. First of all, let me spend a few seconds to give you a framework. I mean, because as we learn listening our friends, there are different projects, different technologies, different jurisdiction, location, cultures, and so on. So contracts are not always identical one to the other, even if we work mostly always in the same sector of engineering, which for our company is petrochemical, fertilizer, oil and gas, and power projects. Notwithstanding the above, whether you are in the Middle East or in other sides of the world, certain terms and conditions might change. With the different level of power negotiation in our hands, depending on whether we are negotiating contracts with the owners, big state companies for projects worth billions of US dollars equivalent, or subcontractors. We are always talking about very high technical complexity, so let's never forget about the need for having also good experts on board every once in a while, because we are talking about very technical issues. So lawyers, in-house counsel like me, or contract negotiator, they have always to try to deal with these very complicated matters, which are not always identical. Why make this premise? Because if we go through definitions, we might distinguish few very common stages, phases, whatever you want to call them, which dictate certain deadlines, linked to which we have certain liabilities and risks to be taken, which are always backed up by bonds being executed or not, depending on the good performance of contractors and owners. Mechanical completion is the first definition I'm asked to give to the audience. Can change as a definition. There are contracts where, for example, pre-commissioning is prior mechanical completion, other cases where those activities are after mechanical completion. But going straight to the point, mechanical completion basically refers to finish construction of a component or equipment, then usually occurs when works has been constructed in accordance with engineering records, and activities specified in the scope of work for mechanical completion have been completed, including verification that the unit, and I'm talking about unit systems or sections, to make also the audience understanding that sometimes mechanical completion can be related to only a single piece of the project. If there are different facilities, different units, different sections, you may have different deadlines, different milestones, different LDs applying at different time, and different situations. So I'm not to keep the scenario too open, but just to give you the framework that the strict definition working everywhere for each kind of project, not even in our very specific sectors, work always in the same way. Mechanical completion, usually respectful to a unit or to the overall completion of a plant, requires the fulfillment of several conditions that usually are the inspection and testing being completed, the exception items rectified, if any items needs to be approved in writing by the owner, the importance of put everything on writing, the ready to commence pre-commissioning and commissioning, so that after mechanical completion, basically you can start doing these activities, which will lead you to the provisional acceptance or practical completion, as we want to call it. Always on mechanical completion is important to deliver job sites to the job site the spare parts, and pay eventual liquidated damage or negotiate on payment of certain milestones if there is a deduction to be made, and so on. Operation and maintenance manuals and as-built drawings will be released, and the performance bond relating to what Andrew also said before, they are supposed to remain valid and enforceable, because that's not the time when we can get rid of this big risk, which is a first written demand call for a bond of this magnitude, usually 10% of value of projects that in our case are worth billions. So you can imagine how careful we have to be. I say there are different mechanical completion related to overall completion or unit, system, or sections. It goes by itself. I don't think we need to provide more details about that. The important thing when we come to practical completion is to go back to the sequence I mentioned before, the generic sequence, which is mechanical completion, partial acceptance, and final acceptance. What is in between mechanical completion and partial acceptance? Probably I'm saying very obvious things, very basic things, but they count very much in our world. I mean, of course, you have to do the pre-commissioning, commissioning, ready for startup. You need to perform all the tests that you have to perform in order to basically get to the so-called provisional acceptance. The PAC certificate, the PAC, as we say in Italian, PAC, opposed to FAC, which is a bad sounding word, but for us is a good word, because after the final completion, we are very happy if everything went fine. So what I would like to say that for the provisional acceptance certificate, which is when you can say that the partial project commercial operation date is deemed to be there, or is certified through a certificate, means that basically the partial or overall mechanical completion has occurred, that all tests and completion occurred, that the performance liquidated damage, if any, and not only delay liquidated damage, performance, because test has been performed in the between mechanical and provisional acceptance, went fine. So hopefully everything went well, and otherwise some money is to be paid back to the owner. Hopefully not. Exception items, again, permits, per parts, or these other details are included in the certification of provisional acceptance. What counts, I guess, very much in this discussion is, for example, the exam of a case study we can mention. Probably I'm already anticipated your next question, but it's very much related to what has been discussed also before by our colleagues. Is what is the level of let's say liability between the mechanical completion and partial acceptance, provisional acceptance, practical acceptance, whatever you want to call it, in case there is some activity were supposed to be performed by the owner and not by the client. This is very important, because if you're liable until the provisional acceptance for the performance bond, then of course there is another bond substituting the performance, which is the warranty bond from partial to final, but let's stay to partial. even the performance bond can be released if the performance test went fine. And what if I cannot perform tests properly because, for example, the owner doesn't provide me as with the feedstock or with whatever is necessary in order to complete our performance test. At that time, in that moment, of course, we cannot be considered liable if a certain test is not achieved. We have cases of owners delaying or not having provided yet what they were supposed to provide. Let's go back 1 second. There are contracts where care and custody and liability of commissioning and other activities prior to partial acceptance are being passed to the owner already at the mechanical completion, which is the safest position for us, wherever we can negotiate contract like that. If this risk doesn't pass to the owner at that time, then we might have an issue if the owner is not providing feedstock, is not allowing us to move from pre-commissioning, which is more our business probably, to the commissioning itself, which depends completely from something coming from the owner, from the employer, which is feedstock, which is sometimes also manpower. We have cases of this activity from the owner not being provided in due time, or not at all. At that time, we manage sometimes to negotiate a way out, which is the most glorious situation, where we are waived from the positive conclusion of performance test. Means that what is the provisional acceptance is something you achieve anyway, because you cannot have any influence on a positive or negative achievement of that milestone, which is extremely important, because then we can get rid of the performance bond, which is, as I say before, a huge amount of money. Then between the last point and the very last point, which is the final acceptance, is only a matter of defect liability period and the correction of any eventual defect from the provisional acceptance to the final acceptance. But I don't think there is so much to discuss over here. What I can testify, what I can try to say, even if I'm not allowed, suppose, and authorized to disclose anything more than that, is that there are cases we have been facing, we faced case, we have to deal with cases, we are dealing with cases where, with the owners not providing feedstock, not collaborating, not cooperating in order to allow us to finally achieve at least a pack, the ways are claiming for, as Andrew say, if I'm not wrong, of course, additional extension of time, additional compensation, and payment of the manpower that sometimes we have to provide instead of the owner. So changing a little bit the scope of work, making variation changes in order, which need to be compensated. So if we claim properly at the right time in written form, following the contracts, and be very careful not too much, let's say, easy to get piss off too much about things, and if we stay calm and work properly, we can avoid disputes. If we cannot avoid disputes, sometimes is sometimes, unfortunately, a way to get to an agreement. I know very well I'm saying very obvious things, but I have, as a dispute resolution manager, I had to face cases where termination was very close from both the two parties, even if there was not 1%, but a little bit more of progress still to be completed. But however, we were absolutely convinced that we were impeded. We were not put in the right position. Inadimplenti no est inadimplendum, no? So I mean, we had proper title to freeze the project, to suspend activities, to claim for money, and when there was not a proper answer in due time, we even started litigations and arbitration. Sometimes we managed to use that as an instrument to find an agreement and to get out of the issue, continuing to be friends and finishing the job. This is a little bit the overall. I hope I was not too. It was clear enough.
Yes,
what is the
yes.
real world from the in-house point of view?
Yes, yes. Thank you, Johnny. Thank you
You're
so much
welcome.
because it was a very elaborative explanation, and we are able to understand as an audience that how it actually happened in the project from case to case. Thank you so much. Moving on forward, I'll ask to Farhan that as a delay expert, when you are taking delay analysis in projects where overall completion is not achieved and snag items are pending, and there's those snag I believe, like usually do not have any planned dates on the baseline schedule. Like the contractor does not plan the snag items as an activity in the baseline schedule. So how do you handle such scenarios while performing delay analysis?
Sure, Ravina. Thanks for this question. Yeah, I mean, I've been listening to all the esteemed speakers, and they've all brought in the legal aspects of this issue. So, being an engineer and being a delay expert, I'll try to bring in some technical aspects on how to go about navigating when you face such challenges. First of all, I'd like to emphasize that I'd like to emphasize the importance of a baseline. Baseline serves as a benchmark to measure project progress as well as the performance. However, we have seen that the contractors or the employers many times only focus on the major milestones of the project and only on the critical path activities, and quite often ignoring small items like snag list, like it is apparent from your question. Nonetheless, if something of like snack kind of activities are not there in the baseline, how we then approach is first we identify and categorize the snack items. So this will involve like going to site, doing site inspections, consulting with the project teams to build up or compile a comprehensive list of pending tasks. So see, the snack items can be like, as my previous speakers have said, they can be very small, minor cosmetic issues, or they can be significant functional deficiencies. Next, once we have the compiled list, we assess the impact of these snag items on the overall project completion. How we'll do is this involves determining whether these snag items affect the project's critical path or if they can be completed in parallel without delaying the overall project handover. Now, in absence of baseline, what we'll do is we develop a detailed completion schedule for the snag items. So quite often we emphasize on this is that this schedule has to be very realistic and based on current site conditions, resource availability, and considering all the constraints. So herein, deep coordination with the project team who are actually involved in reviewing or completing the snag items is very much required to ensure your completion schedule is accurate. Once you have these snag items ready, you incorporate this detailed schedule into your delay analysis. This helps us to understand how the pending snag items contribute to delays and allows us to allocate responsibility appropriately. By doing this, we distinguish between delays caused by these items from other delays in the project. Once you have the delay analysis done for these snag items, we finally communicate our findings and recommendations to all the stakeholders. This involves providing a clear explanation of delay impacts, the steps required to complete the snag items, and any other recommendations to prevent similar issues in future projects. So in conclusion, what I can say is that handling snag items in delay analysis requires a meticulous approach to ensure that all the pending tasks are accounted for and their impacts are properly assessed. Proactively including a buffer for potential snag items in your future baseline schedules can help you mitigate such challenges. That's all I have to speak on this.
Thank you, Paran. It was a quite interesting because we were hearing till now the legal aspects and perspectives, and now we know the technical aspects of the delay analysis to be done when there is such a circumstance. So moving on forward, I would like to ask Andrew that now when we understand that the contractor and the employer have to think calmly and to have work upon the final completion of the project, and how to attain practical completion is a big task as we understand. So I would like to ask you that can a contractor claim for practical completion if the employer has started making the commercial usage of the project, however has not given any certificate or has not given any proof or evidence that it has been completed? What is your take on the English law? Because for instance, like in my experience, I had done a railway project analysis where the trains were running on the entire length. But then on the same time, there were pending items, there were snag punch list items, and the completion was not done till almost a year, 2 years later. So can the practical completion be declared in such a scenario?
Thank you, Irina. So Lucy touched upon this earlier from the position under English law with respect to properly defined snag items. So there tends to be amongst parties, both employer and contractor, sometimes a dispute over what is actually a snag and what is actually a substantive element of the work. I've seen it where employers try to allege that a substantive element of the work is indeed a substantive element of the work, and the contractor is trying to then flag it as a snag item. So critically, it's important to make sure that the definition of the works in question are actually snag items. If they are minor items, then the employer cannot resist or indeed challenge that practical completion has ultimately been achieved. And there's a substantive case law on this. The added dynamic here, obviously, is the use of the facility or the infrastructure project, or in your case, the case example you gave is a railway project or a rail project. If fundamentally there is a use being derived from the project, it's very, very difficult for the employer to then maintain that practical completion has not actually been achieved. Now, obviously, it's important to look at the contract, to look at the requirements to achieve practical completion under the contract. But if indeed the occupancy has been taken over by the employer, that the use of the item in question, the project in question, is clear and can be clearly defined and documented, then it's a very difficult position for the employer to try and argue otherwise. From my own personal experience, I have seen employers dispute whether they're actually using the facilities. On a hospital project in Abu Dhabi, there was an instance where medical equipment was moved into the building. And ultimately, the contractor then said the employer has taken custody of the building, possession is clear, and therefore we've achieved practical completion. And then they wanted to start instigating the contractual obligations under the contract for practical completion being achieved, including the return of various bond monies. Now, in that instance, and this is why it's important to look at it from every individual case, that was not possession. That medical equipment was required in order for the testing and commissioning phase of the works, which was still part of the program. Indeed, it was on track for the hospital, could be achieved. So the contractor had been rather sneaky in that instance to try and claim that possession was effectively a de facto matter, when in actual fact the employer was simply moving the equipment into the site to allow for testing and commissioning to take place. In that instance, the testing and commissioning revealed a substantive amount of failings in the MEP works, which the contractor was also responsible for, and had known this was coming in and tried to utilize this event to their advantage. So if possession has been taken, but has been taken for the right reasons, i.e. utilization of the facility, and I think the rail project's a very good example. If the trains are running and value and indeed returns are being made by the employer, it is wrong contractually and legally for the employer to try and argue that practical completion has not been achieved. We have seen it certainly in the Middle East. I know of a project that was running for 3 years where use was utilized by the employer, and yet in the arbitration, which commenced a year after possession, the employer still maintained that practical completion has not been achieved. And that ultimately impacts your credibility. No tribunal is going to sit there, well, wait a minute, the trains are running and you're making money out of them. You're selling tickets, you're utilizing the infrastructure, and you say that practical completion has not been achieved. It's a very difficult position to maintain. So think through the specifics, make sure, again, document everything and make it clear what you're dealing with from that perspective. But the employer should be mindful of the fact pattern and what they're doing, and mindful of when they take possession. Make sure they document what they're doing as well.
Okay, understood. Thank you, Andrew. So I would like to ask, for the benefit of the audience, that to Aarti, that what is the position of UAE law in such instances?
Thanks, Ravina. And I'm really sorry, but I'm going to have to repeat. I'm going to have to repeat this. But Construction contracts often have a very subjective criteria to a contractor's entitlement to the TOC. And every situation is unique, and really it will depend on the specific contractual terms and the specific factual circumstances present. But as a matter of UAE law, apart from the provisions I've touched on, such as good faith, abuse of rights, and just enrichment, the UAE Civil Code provides that if there is no valid reason for an employer not to take delivery of the completed works, the risk or care of the completed works shall be deemed transferred to the employer. And this deemed completion is necessary because the contractor should not be penalized if the employer prevents completion. For example, the employer's use or occupation of the works may cause damage or disruption that is outside the contractor's control. Now, if substantial outstanding works remain, it is advisable that the employer does not make use of the works. So this can be particularly challenging, especially if the project has already been subject to significant delays. We have seen some, in practice, we have seen some employers try to mitigate this by issuing the taking over certificate as a commercial decision and noting in the TOC that the contractor must still complete the outstanding work. However, this is a very difficult road to go down and can lead to significant issues. That's all I really wanted to say. Thanks.
Thank you, Aarti. So I understand, I'm aware that we are running out of time, but I would like to ask one last question to Farhan regarding delay analysis, where we understand that how can a contractor claim for losses due to extensive disruption and severe productivity loss during the period which we are talking about, that is the period between practical completion and the overall completion, when we are addressing the delays in snacks that are caused by the factors which are beyond control, like beyond contractors' control or beyond employees' control, both vice versa. So I'd like to hand over to Farhan to answer the question.
Sure, Ravina. Of course, the claim for any kind of losses, whenever we come across such scenarios, we always emphasize on to our clients is document. You have to maintain thorough documentation of all project activities right from the beginning of the job. That would include like schedules, timelines, and communications. What this helps is in establishing a clear cause and effect relationship between the delays and the resulting productivity losses. So you have to document each and every event happening at the project, be it like extreme weather conditions, supply chain disruptions, or unforeseen regulatory changes. You can include photographic evidence, weather reports, and all those things. And along with that, for preparing any kind of claim, be it snag related or any kind of claim, like my previous speakers have also touched upon, is you have to refer to the contract. You have to refer to any force majeure clause, which entitles the contractor to claim for such delays, which can give you a very strong foundation for your claim. You have to look at the EOT clause, what it says. You have to look at the notification clause, whether you are notifying the employer in the stipulated contract time for any kind of delay that you are facing. And most importantly is communication. You have to, as soon as the delay occurs, you have to promptly notify the client and other relevant stakeholders in writing, providing detailed explanations and with all the supporting evidence. Now, when it comes to quantifying the losses, of course, now in my previous question, when you had asked me, I had explained how to do a delay analysis for snag items, right? So here in terms of quantifying, you have to calculate the costs that were incurred because of this extended project duration. So the costs you have to consider could be labors, equipment, site overheads, and materials, as well as costs such as administrative overheads, loss of opportunity, and additional financing cost due to the prolonged project duration. Once you consider all these costs, you put in the delay numbers in the critical path analysis, and then you multiply the cost incurred along with the delay number as per the delay analysis, and derive a certain amount. Once you derive that, you prepare a very formal claim submission that would include all the collected evidence, document impacts, and a clear explanation of the reasons behind the delays. Ensure the claim is structured with according to the contract requirements. So at this stage, what we always suggest our clients is to consider consulting with claims consultant to strengthen the claim. This expertise can really help in presenting a very robust case. So therefore, I think if you can systematically claim for losses incurred due to delays between practical completion or overall completion, you can ensure the rights as a contractor or the employer, vice versa, are protected while also working towards a fair and amicable resolution of the dispute or of the project.
Thank you, Farhan. Understood. So I guess this was my part of last questions. I would ask the audience again to see, like to ask if they have any further questions. I'm able to see one open question, which is how can parties negotiate milestone payments to align better with the realities of project completion? So I'd like the speakers to, if they would like to address it.
Well, I can give that one a go if you want, Ravina.
Sure.
I'm obviously not usually involved at the drafting of the contract stage, but obviously the parties are free to negotiate whatever milestones they want. So I don't know whether the questioner is talking from a standpoint where the employer is perceived to have all the cards at the negotiation stage and can therefore set the milestones how they wish. But if the other side doesn't like the milestones and doesn't think they're actually going to reflect the realities of how much work are involved at each stage, then the only way they can change that is by saying no, I won't agree to it, and setting out what they want to agree to. It's not really a legal point. It doesn't. I don't think it's more just what can you get across the table in the negotiation at the beginning, and what can't you?
Well, there are, if I may, there are stages before the commencement of a project during the contract negotiation. Sometimes there are, let's say, possibilities with big owners, big employers are very difficult to be negotiated so much, which specifically identify milestones for achievement of certain activities, certain stage, certain phases, which are crucial, which are in the critical path, by the way, connecting to what was said by our friend before, by our colleague before. And once is negotiated before the commencement, before at the signature of the contract, then becomes very difficult to change those kind of parameters and clauses about payment through milestones, which probably remain what can be renegotiated during the course of the project if something goes wrong, or the sequence of events is not exactly the one that was supposed to be. Then depending on the strength you have with your counterpart, there are always rooms, or at least a way to try to negotiate. Claiming in a proper way, and contracts sometimes they also define how to make this kind of changes, basically, in the contract. So our contract changes, which follow rules defined by the contracts, and not always is so easy, even following the procedure defined and the way through defined by the contract themselves. Therefore, you start claiming the best you can, and if claims don't work, if a claim doesn't work, then you start a dispute. If it's really unavoidable, I would say, if it's really unavoidable, if you're going to lose a lot of money, or the situation, the change of the scenario is going to expose you to an unbearable risk, then you have better to try any way through, any way around, even starting, unfortunately, a dispute. If worst come worst, you have to use all the instruments, even the dispute resolution clause, properly addressed, properly used, hopefully properly drafted. Okay.
Definitely, yes. So yes, we have another question from an anonymous audience, I guess. So how do you define substantial completion in contrast to practical completion in engineering projects? And what are the key legal implications of each term? This is again a similar question. So if I'm not sure if anybody wants, it is open for all the speakers.
So to other people's thoughts, I'm happy to answer. I mean, ultimately, it will come down to what the contract says. This is there is case law on this, both from a UE law and English law perspective. But if the contract defines substantial completion specifically, then you must look to the contract. Practical completion is, in many parts, as one of the speakers said earlier, a subjective term that can be defined not just by the contract and by the law, but by actions of the parties. As we've discussed in relation to this, substantial completion carries with it different knock-on effects, and other different milestones are triggered as a result of achieving substantial completion. The practical completion I've always found is somewhat easier to define because it's where the majority of the works are complete. We've discussed earlier how you have possession that can be taken over in use of the project. At that point, that doesn't tend to happen with substantial completion, which is slightly further down the progress ladder to a certain extent. But again, subjectively, it depends on the project, depends on the contract. I won't get too hung up on the terms unless your contract specifically specifies certain actions or obligations that kick in upon either substantive completion or practical completion. At the end of the day, the party's key focus must be to complete. And it must be to complete in accordance with the critical path under the programme and make sure all the milestones are complied with. Only then can you properly close out a project and ultimately avoid potentially going to a formal dispute proceedings and incurring a great deal of time and cost having to grapple with that issue.
Andrew, I would add that it could be helpful in our kind of contracts, let's say, to identify the time when you can talk about a commercial operation. So when the owners can start operating and getting any benefit selling the products out of his plant, even between the partial, what I defined before as a partial provisional acceptance, and final acceptance. Already there, of course, there is an operation of the plant, and to even slightly before the provisional, if the plant is already operating, is not a matter of percentages of progress. Is a matter of output being sold on the market and causing an unjustified enrichment from the employer if the employer does not recognize the proper payment to the contractor. That's my let's say point of not return is the commercial operation.
Thank you, Giovanni. Thank you so much.
Yeah.
Yes, I agree too. So yes, I'd like to wrap this up masterclass. I would like to say that as we near the end of today's masterclass, I would like to thank all of the panelists joining us today and all the audience members for their active participation. I'm sure that the insights shared today by all our panelists were invaluable. I hope you found this session extremely informative and thought-provoking as well. Once again, thank you everyone for joining us today. On behalf of Mason, I wish you all a wonderful day ahead. Goodbye.
Thank you, Ravina. Thank you, everybody.
Thank you.
Bye. Thank you.
Thank you.
Bye.